This is Bloomberg Law with June Grasso from Bloomberg Radio.
Last term, agency power took a hit at the Supreme Court as its conservatives overturned a 40-year-old precedent and put new constraints on regulators. But conservatives are not done with their attack on the so-called administrative state, as more issues are coming to the court that would further gut the authority of federal regulators. And the upcoming issues could be even more consequential if the court considers two far-reaching arguments. One threatens a multitude of laws that let agencies set clean air standards, establish workplace safety rules, and determine unfair trade practices. A second targets the independence of the Securities and Exchange Commission and perhaps even the Federal Reserve. Joining me is Bloomberg News Supreme Court reporter Greg Stohr, who has written about this. Greg, for those who don't remember, explain what the Supreme Court's conservative justices did about agency power last term.
Well, they did a lot of things, June. The biggest headlines were they overturned a 40-year-old precedent that had basically said if there's a statute and it's not clear what it means, that the courts will defer to the agency about what that ambiguity means. That was known as the Chevron doctrine. The court overturned that. And what it means going forward is that judges are going to have a lot more power to strike down agency actions, and agencies will have less authority to define the scope of their missions. There were a couple other big decisions the court issued as well. It's definitely a theme of this court to limit agency power, but that was the biggest case.
Address this in not only her dissents, but at a judicial conference this summer.
Yeah, so Justice Kagan, who in her previous life was an expert on administrative law, a law professor, she dissented from all the courts, the big three rulings from this last term. And at a judicial conference in July, she mentioned that, the court's pretty clear about what its goals are here. That the conservative majority, she said, just thinks there's too much agency regulation going on. And so, what we're seeing is critics of federal regulation sort of trying to leverage that predisposition that the court has to limit agency power, and they're lodging a whole variety of arguments at the court.
Last term, we learned about the Chevron doctrine, for people who didn't know. This term, we're going to learn about the non-delegation doctrine?
Yeah, we may well. And if we don't learn about it this term, we will learn about it in a term coming to you very soon. The non-delegation doctrine, unlike Chevron's all about how to interpret statutes. It's not a constitutional question. The non-delegation question is about constitutional power, and the question is whether when Congress delegates some of its authority to, say, a regulatory agency, what sorts of guidance does Congress have to give that agency? And for the past 90 years or so, the Supreme Court has basically said, yeah, it doesn't have to give a whole lot of guidance. It can delegate some really important things to agencies, and as long as there's a so-called intelligible principle, that's just fine. And a lot of conservative advocates, conservative jurists would like the court to reinvigorate that doctrine, to put restrictions on Congress so that if it is going to try to delegate some authority, it's got to be a lot more clear about what the agencies actually are supposed to do.
That sounds almost like an uphill battle. I don't know if it's a battle that can't be won, considering how little Congress passes nowadays and how difficult it is to get anything through.
Yeah, so this doctrine, known as the non-delegation doctrine, could really, A, it could overturn some previously enacted statutes, and B, as you said, given the deadlock that is so often a feature of our political process these days, it could, make it virtually impossible or very, very difficult for Congress to muster the will and the coalition needed to put in place the kind of law that the Supreme Court would approve of.
This non-delegation doctrine would apply to all agencies.
It would apply to every federal agency. Obviously, every federal agency is different, so exactly how it applies, might depend on the statute. And it will also apply, and one case that the court could decide to take up in the fairly near future, it could apply when an outside entity, a non-governmental entity, plays some role in putting regulations in place. So there's also the notion that Congress has even less power to delegate things to private entities.
Are we talking about environmental rules, workplace rules, things like that?
Yeah, so one place we saw it, the court turned this case down, but one place we saw it very recently was a very broad challenge to the power of OSHA, the Occupational Safety and Health Administration that sets workplace safety rules. And the challenge, which again, the court didn't take this one up, but the challenge was that Congress had given OSHA way too much power to just decide what is an unsafe workplace practice. So that's one example. Could certainly apply in the context of the EPA. Absolutely. There are, of course, a lot of different sorts of attacks on the EPA. It could apply, and it's being raised with regard to the Federal Trade Commission's effort to ban non-compete clauses in employment agreements. The question is whether Congress has delegated to the FTC the power to decide what is an unfair trade practice, and that's the mechanism the FTC used to enact this ban. And the question is whether Congress was specific enough there. So it's a pretty wide and potentially very, very important legal doctrine.
And there's an FCC case?
There is an FCC case, and this may be the one that the court agrees to take up. This has to do with the so-called Universal Service Fund. That's the program that is used to subsidize the monthly phone bills in rural areas and for poor people. And it's funded by a charge that shows up on everybody else's or every phone bill. And the question goes to how the FCC determines what that charge is going to be from year to year. And this is one of those cases where it relies in part on some assistance of a private entity. That's a case where a federal appeals court, not surprisingly, it's the conservative Fifth Circuit, has said that is a violation of the non-delegation doctrine. And that's a case that sometime in the next few weeks, the Supreme Court may well say it's going to hear.
And Greg, it was during Franklin Roosevelt's term that this was used?
Yeah, this is, I mentioned the court has had kind of a low bar for the delegations for the past 90 years. Well, 90 years ago, it was actually 89 years ago, in 1935, where only two times the Supreme Court has ever struck anything down on the basis of the non-delegation doctrine. There were two cases stemming from the New Deal. I'll spare you the details of the program, but one case is colloquially known as the sick chicken case. The other one's colloquially known as the hot oil case. But since then, the Supreme Court has not struck anything down under the non-delegation doctrine. But in more recent years, the court's conservatives have in various forms strongly suggested that they are interested in reviving the doctrine.
And there are some cases that are targeting the independence of federal agencies. Tell us about that.
Yeah, this is another issue with its roots in the New Deal. There's a 1935 decision that also went against Franklin Roosevelt. What it did was it said that Roosevelt did not have the authority to fire a member of the Federal Trade Commission for any reason. Congress had put in place job protections for the FTC commissioners. Those job protections are still in place. And the question is to whether those job protections are unconstitutional, violating separation of powers. And if the answer to that is that does violate separation of powers, then it calls into question all the administrative agencies, all the independent agencies that are out there. So we're talking about the Securities and Exchange Commission. We're talking about the Federal Trade Commission, the Federal Communications Commission. There's a whole slew of those executive branch agencies. And the argument is basically that they need to be accountable to the president because they are executive branch agencies. And the folks who would like to put those agencies more firmly under presidential control are looking at the possibility or arguing for, in some cases, overturning that 1935 decision known as Humphrey's Executor.
The agency that comes to mind that the Supreme Court has had a lot to do with recently is the Consumer Financial Protection Bureau. Tell us how the court has ruled with respect to that.
Yeah, so a couple of years ago, the court said it is unconstitutional to give job protections to the director of the CFPB. They struck down those job protections. That means that the director of the CFPB can now be fired by the president. And in that case, they distinguished Humphrey's Executor. What they said was, hey, Humphrey's Executor involved a multi-member commission. The idea was that you want to have some expertise on this commission. You want to have sort of institutional knowledge. And the court said, it's different when you have a single person heading an agency. That person, the CFPB director, has an enormous amount of power, and he or she really ought to be accountable to somebody, namely the president. So the court left open the question of independent agencies like the ones we were talking about earlier. It said that with regard to agencies that are run by a single person, at least when they have as much executive branch power as the CFPB director has, that is unconstitutional.
And our listeners will be concerned about the Fed, I think. I mean, would the Fed fall if all these agencies do?
Yeah, that's a really good question, because exactly how you distinguish the Fed from the SEC and the FTC, not entirely clear. The people I talked to, and I talked to the story I wrote, I talked to a number of people about kind of what the next priorities are in the world of administrative law. And without exception, folks said, I think the court will be skittish about calling into question the independence of the Fed. You know, its independence is really a bedrock of our economic system. So, you know, it's a good question. The courts will probably want to tread carefully. You know, there's not a guarantee about how it will come out, but the court, you can imagine, will hear a lot about the importance of Fed independence being a bit apart from the political processes, if indeed they do take up this issue of Humphrey's executor.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Bloomberg Supreme Court reporter Greg Stohr. We'll take a peek at the term coming up and see if there are any blockbuster cases. I'm June Grasso, and you're listening to Bloomberg. There's a possible challenge to the Consumer Protection Safety Commission.
Yeah, this is a case that is on the so-called long conference list where the Supreme Court, as soon as they come back in early October, will decide whether to take these cases up. And there is a case that challenges the independence of the Consumer Product Safety Commission. In that case, the petitioners are saying, hey, you don't need to overturn Humphrey's executor. We can actually make the case that the Consumer Product Safety Commission is different today than the FTC was back in 1935. But we've seen in other contexts that the court sometimes goes beyond exactly what the parties are asking for. So it would at least call into question, if the court would agree to take up that case, it would at least call into question the survivability of Humphrey's executor and therefore all these other independent commissions.
You know, I foolishly thought that the court might take a step back, from these groundbreaking decisions, landmark decisions, considering that a lot of their other landmark decisions, like doing away with the Chevron doctrine, taking away abortion rights, the Second Amendment decision, have led to so much litigation in lower courts who are confused about what the rules are. And it seems like this is just going to cause more litigation.
It will certainly cause more litigation if the court goes there on these two areas of law. This is not a guarantee they're going to take these issues up on the very first opportunity. It's possible they will hear people like June Grasso talking about all the confusion in the lower courts, and we'll say, maybe we should let the dust settle a little bit. We will almost certainly also get cases coming up that are dealing with that confusion that you were talking about. The decision, the overturning Chevron, the decision known as Loper-Bright, undoubtedly is going to foster some confusion that the court may feel the need to clear up. There's another big decision the court issued last term having to do with the right to a jury trial. If the SEC is going after you, that may also spawn some follow-up issues. So the court may feel like it has its hands full with those issues. We're just going to have to see. But what is clear is that folks who think the administrative state has too much power certainly has some other big goals in mind, some other significant things they would like the court to do, and they're going to be asking for that.
Last year about this time, there seemed to be a lot of blockbuster cases lined up for the term. Do you see any blockbusters for this term so far?
I would say so far the court has not agreed to hear any blockbusters. There's plenty of time to add other big cases for the winter and spring. The cases that the court has agreed to hear in the fall, probably the one that will get the most attention has to do with transgender care and laws in about 24 states that ban so-called gender affirming or gender transition care for minors. That's the case the court will probably hear in December. And, of course, there's a possibility that we'll have a significant election fight, so everybody's kind of holding their breath for the possibility of that.
Are there any abortion-related cases coming up? Last term, the Supreme Court took up that Idaho case over whether a federal hospital law guarantees that patients can get abortions to prevent a serious health risk, even in states like Idaho that allow the procedure only when the mother's life is in danger. But the justices didn't resolve the issue. Is that case coming back to the Supreme Court?
So the Idaho case, it doesn't seem like that's likely to come back up. There is, waiting for the court, we'll see how they deal with it, a similar issue being raised in a Texas case. It's similar but different. In that case, Texas has sued the Biden administration, saying a policy that the Department of Health and Human Services, a memorandum they put together, cannot be applied to Texas, having to do with whether abortions need to happen on an emergency basis in hospital emergency rooms. I'm sure there will be other abortion cases that come along. Right now, there's not a significant one that is a sure bet for the court to take, and not one that they've already agreed to hear.
I noticed that in the first week of the term, there are oral arguments set in a death penalty case.
It's the unusual case where the court agreed to hear an appeal by a death row inmate. It's a case where even the Oklahoma Attorney General says that the guilty verdict against Richard Glossop should not stand. There's evidence that prosecutors suppressed evidence, including some matters regarding the testimony of the key witness. So the court is hearing arguments in that case, and it's the rare case where a death row inmate has at least a fighting chance to win at the Supreme Court.
Greg, it seemed like at about this time last year, there were a lot more cases that were queued up that seemed interesting. How much slower are they going with granting petitions this year?
It's definitely slow, not so much on numbers, but it's slow in terms of the star power of the cases. This time last year, we had a lot of cases involving, some significant cases involving administrative law the court had already agreed to hear. There were cases that were pretty clearly in the pipeline that the court was almost certainly going to have to hear, including the mifepristone, the abortion pill case. We don't really have that this term. Not a particular reason for it other than those cases don't seem to have come along yet. I would be surprised if we didn't have some pretty significant ones when all is said and done. The court certainly has plenty of time to add some big cases. And there are at least some folks out there watching the court who speculate that they are intentionally keeping things low-key right now with an election coming up, in part because they don't want their docket to get too bogged down with big stuff, because they may indeed have to take up a significant election case depending on how things go.
This summer, I think 3 of the justices, when they were talking to groups of lawyers and judges, either complained about or expressed concerns about the amount of work during the summer from the emergency docket, which is better known as the shadow docket. Was there a lot of action on the emergency docket this summer?
Yeah, it's been a really big summer for emergency applications. The court has had cases involving voting laws, a proof of citizenship law. They've had a case involving the rights of transgender students. They've had a significant case involving Joe Biden's latest attempt to reduce student loan bills. The court kept this newest plan on hold, rejecting the Biden administration in that one. And there are a number of pending applications, things that have been sitting around for a while involving the EPA, including a rule that would put new limits on emissions from power plants to stem climate change. So that's become a pretty regular feature of the court that there are almost always some very significant emergency applications that are in the pipeline. And what often happens with these, for example, the student loan case, that may end up being the final word on that effort. It may be, because who knows what's going to happen in the presidential race, it may well be that the Biden administration never gets to put those rules in place, even though this is supposed to be only a temporary order from the Supreme Court.
And of course, the problem with the shadow docket is that these cases are decided sometimes finally, as you mentioned, with the student loan case, without full argument or briefing. Thanks so much for that preview, Greg. That's Bloomberg News Supreme Court reporter Greg Stohr. The Biden administration is moving to narrow a trade loophole that Chinese online retailers like Temu and Shein have used to ship an increasing number of packages containing cheap goods into the U.S. every day, tariff-free. The Biden administration announced that it intends to propose rules that would rein in the use of the so-called de minimis exemption that allows products worth less than $800 to go directly to consumers without customs declarations or duties. Shipments under the de minimis standard have surged to 1 billion packages last year, up from 140 million a decade ago, overwhelming the U.S. agencies responsible for screening packages for unsafe or illegal goods. Joining me is international trade expert David Townsend of Dorsey Whitney. Tell us about the de minimis exemption.
It's a carve-out from the U.S. import entry process, where an importer is permitted to make what's called an informal entry as its merchandise comes into the United States. And by statute, that exemption is available only if the package is valued at less than $800 and is only entered on one day to the same person. So you can't have one person importing multiple items that are less than $800 and claiming them under the informal entry process. What the informal entry process does is it allows a sort of streamlined entry process where limited information and data is reported to U.S. Customs. And there's a lot of formal data elements that you get to skip if you enter it under the de minimis exemption. And Customs waives or doesn't apply a number of the regulatory requirements that apply to import entries that do not enter under the de minimis exemption.
Has the use of the de minimis exemption gone up in recent years?
Yeah, so I'll just back up in terms of the history of the de minimis exemption, because it has a pretty long history. It's been in effect under U.S. law for decades. Through most of the 90s and early 2000s, it was at $200 per person per day. That was changed in 2015, and in that law, Congress raised the statutory threshold under which importers can use the de minimis exemption. So the exemption went from $200 a day to $800 a day. In 2015, when Congress made this change, it was a recognition that e-commerce had increased, that there was significant benefit to U.S. consumers, to U.S. importers, to e-commerce and retail companies to allowing the use of the informal entry procedure. And so to get to your question, whether it's increased, yes, it's increased many times over since 2015. And it's no secret why that would be the case. First, the amount of customers and U.S. consumers that buy things over e-commerce has significantly increased since 2015. There was a large increase because of COVID-19. Also a large increase, I think, even aside from COVID, just from people choosing to shop online and through e-commerce platforms more than they were as of the date when Congress changed it. So to give you just a few figures about that increase, it's been vast. So in 2015, 2016, when the law changed, there was about 146 million parcels per year that were using the informal entry process. And as of last year, and this year as well, it'll be over 1 billion. So a very large increase. And the value of imports under the exemption has increased in a commensurate amount as the number of parcels.
How much of this is directed at the Chinese retailers Temu and Shein? The U.S. textile industry has complained that the recent boom in e-commerce from those two companies in particular has hamstrung manufacturers.
Well, the majority of imports under the de minimis exemption are from China. And I think, a lot of that increase would be to be expected because the profile of imports from China to the United States has been even going all the way back to 2015 and still today, there's a lot of consumer goods and items sold over e-commerce that would naturally tend to qualify for the de minimis exemption.
Tell us about the executive order and what it aims to do.
Yeah, so the White House on Friday announced several changes to the de minimis exemption. First, there are, as one of the significant benefits of using the de minimis exemption, certain tariffs can be avoided entirely. And the White House aims to, through a notice of rulemaking, is going to eliminate some of the tariff exemptions that applied for the de minimis exemption. And I'll just give you a few examples of those. There's what's called Section 301 tariffs, which are imposed on Chinese origin goods since 2018 by the Trump administration. And Customs had been very clear from the beginning that if you were importing something under the de minimis exemption, you could avoid the Section 301 tariffs. Also, less important, in my view, the White House is proposing to do away with the exemption if what are called Section 201 tariffs, which are safeguard tariffs, apply to the import, or also 232 duties, which are national security-related duties that are imposed on steel and aluminum. Unlike those duties, the Section 301 tariffs apply to about 2/3 of the goods that are imported from China and do cover at least some consumer items, the types of things that you would expect to be in packages that are valued at $800 or less. So the White House is proposing to say, if you have anything in a package that is subject to Section 301 duties, you're ineligible to use the informal entry process, and you must declare it as a formal entry and then be required to pay the Section 301 duties. I mean, one thing, that's significantly changed since 2015 when the de minimis exemption was increased was in 2018, President Trump began imposing the Section 301 tariffs, and President Biden has continued those tariffs. And so critics have been saying, well, this has created a loophole because you can import items from China that ought to be subject to Section 301 duties, but if you do so under the de minimis exemption, you can just avoid it entirely. And what the White House proposed on Friday would avoid that situation by foreclosing importers from using the de minimis exemption for any package with anything that's subject to Section 301.
What happens right away? These are just suggested?
The White House said that they're going to initiate a proposed rulemaking that would prevent filers from using the de minimis exemption if anything is subject to 301. At the same time, the White House said that they think there should be comprehensive reform of the de minimis exemption, which would be done by Congress. As I noted at the start, the de minimis exemption is a creature of statute, so it's established under the U.S. Customs law. So although the White House is going to engage in a rulemaking on the topic, they've also said that at least some of the issues and enforcement problems that people have cited with respect to de minimis ought to be resolved through congressional lawmaking rather than just through administrative action.
Rulemaking takes how long?
Yeah, right. They're going to have to propose a rule. They'll have to open it up for comment. The public will get to comment on that, and they'll have to engage in, a process of addressing those comments and finalizing a rule. So presumably it's going to be months before something is final. And the White House noted that. They said, look, this all could be done more quickly if Congress acts than if the administration does. But they obviously feel like they have the authority to move forward with these changes without Congress acting. And given the political pressure that's been building on this topic, I think they thought they would stay in front of it by saying, look, we're going to do a rulemaking to close the 301 loophole, as it's been called. At the same time, if this is going to be done in a comprehensive manner, it ought to be done by Congress.
Is there a suspicion that a lot is coming in that doesn't really fit the de minimis exemption that's slipping in?
Yeah, so there's sort of two different buckets of issues here. One would be the lawful avoidance of Section 301 duties that I've described. But then the second is that because the import process is informal, it requires less data, that there's a lot of merchandise entered under the informal process that is not lawfully eligible to be entered under the de minimis entry process and that isn't eligible to be imported into the United States at all. So I'll just give you a couple of examples of this sort of unlawful evasion of U.S. Customs Police authority that people are concerned about. One is that items that may have illegitimate intellectual property or trademarks on them are able to be imported under the de minimis exemption without customs fully enforcing U.S. law related to IP. And then another is narcotics. So that's another example where people have said illicit substances are able to be imported into the United States under customs nose because they're not getting full visibility into certain import entries that might contain drugs or precursors to drugs that people can use to make into illicit substances. And customs has acknowledged that these are blind spots for them. As one of the things U.S. Customs did earlier this year, they issued a rulemaking related to the type, what's called Type 86 entry, which is an entry where you take advantage of the de minimis exemption, but you still report certain limited data to U.S. Customs through their electronic system. And they said when they were altering this Type 86 entry process, they said, look, we have enforcement concerns given the rise in imports under the de minimis exemption. We just cannot meaningfully police everything that's coming in under this. And so their solution was to broaden at least a bit the amount of data elements that importers have to report to customs as they're using the de minimis entry process. And that was done back in January. I think it was made effective in the first quarter of 2024. The concerns about enforcement have not abated at all since then. In fact, they've grown even stronger. And so you see customs in this position where they're acknowledging, we cannot fully enforce U.S. law under the volume of shipments we're seeing under the de minimis exemption. And that brings you to the White House action that was taken on Friday to narrow the circumstances under which importers are allowed to use the de minimis exemption. Although one of the elements is that anything subject to Section 301 tariffs would be ineligible to use the de minimis exemption. There also, as part of the White House proposal, is going to be a rulemaking relating to how importers declare the de minimis exemption and the data elements that they have to share with customs. So you see both the duty avoidance issue related to 301 that we talked about earlier, but also these other larger enforcement issues relating to IP, relating to narcotics and other items entering the United States that shouldn't be lawfully entered.
And lawmakers have warned that products illegally made with forced labor can avoid detection with this de minimis exemption.
Also a significant concern here is as part of the Trade Enforcement and Trade Facilitation Act of 2015, Congress addressed and narrowed an exclusion for imports relating to forced labor. And that is another issue that since 2015 has become a significant flashpoint. And so when you look back to those legal changes that were made in 2015 by Congress, you have Congress, expanding the de minimis exemption up to $800 and at the same time tightening U.S. import law related to an enforcement issue, which is forced labor. And the importance of forced labor for Congress and other policymakers in the United States has really grown significantly since then. And so that is another sort of flashpoint and reason I think you're seeing a lot of discussion about reforming the de minimis exemption under U.S. law, whether it's by executive action like the White House is doing or through a potential statutory change by Congress.
It's certainly a critical issue. Thanks so much, David. That's David Townsend of Dorsey Whitney. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.